Good afternoon and welcome to the last panel of the conference, The Academy and the Pursuit of Peace and Human Rights. My name is Milena Sterio and I'm a professor at the Cleveland Marshall College of Law down the street and also have the pleasure of serving as managing director at the Public International Law and Policy Group, an organization that we will hear a lot about during this panel. The panel will be completely interactive. We have sat through a long 2 days of conferencing, and it is time for a more interactive format. I hope you will all agree with me on that one. Instead, our esteemed panelists and I will engage in a series of questions and answers and a discussion about our general theme of how the Academy can influence and shape the pursuit of peace and contribute to the protection of human rights. Before we begin, allow me a brief moment to introduce the panelists. So let me start with Paul Williams to my left. Paul is a professor at the American University Washington College of Law and also at their School of International Affairs, and also co-founder and president of the PILPG. Paul received his AB from the University of California, Davis, his JD from Stanford Law School, and his PhD from the University of Cambridge, where he was a Fulbright research scholar. Paul has given over 150 public lectures and presentations covering topics such as the Dayton peace negotiations, the Rambouillet negotiations, the dissolution of the former Soviet Union, the Nagorno-Karabakh crisis, and many, many others. He's the author of numerous law review articles and books, including his latest book, Lawyering Peace, which is being published by Cambridge University Press as we speak. Paul, is the book out yet?
I signed it to my students.
So any minute now, yes. And to kind of make this a little bit more fun, I'm also going to share a random fun fact about each of our panelists. So Paul was once a blackjack dealer at a casino in Tahoe. Next, we have Drew Mann. To the farthest left. No, this is not about politics at all, but to my farthest left. Drew is a former State Department diplomat. Drew has served as Deputy Chief of Mission at the U.S. Embassy in Colombo, Sri Lanka, as Counselor for Political and Economic Affairs at the U.S. Embassy at The Hague, Netherlands, as Team Leader for the Provincial Reconstruction Team in Tikrit, Iraq, and also as an expert on mission to the International Criminal Tribunal for Yugoslavia. Drew is a recipient of the American Foreign Service Association's 1994 Rifkin Award for Constructive Dissent against U.S. policy towards Bosnia. The Rifkin Award honors individuals who have demonstrated the intellectual courage to challenge the system from within, to question the status quo and take a stand, no matter the sensitivity of the issue or the consequences of their actions. Bravo, Drew. A cum laude graduate of Wake Forest University and the University of Idaho College of Law, Drew clerk for the Honorable Paul Roney Jr. at the 11th Circuit Court of Appeals and practiced law in Tennessee, Washington, and Alaska before joining the Foreign Service. And a fun fact about Drew once worked at Tinkerbell's toy shop at Disney World. Next, we have, to my farthest right, we have Darin Johnson. Darin Johnson is an associate professor of law at Howard University School of Law and the director of the Master of Laws program. Darin received his BA from Yale College and his JD from Harvard Law School. Immediately following law school, he served as an honors attorney at the Pentagon. After departing the Pentagon, Darin continued to practice law as an attorney advisor in the U.S. State Department Legal Advisor's Office. In 2007, he served as the legal advisor to the U.S. Embassy in Baghdad, Iraq. Darin also served on detail to the Office of the White House Counsel in 2011 and from 2011 to 2012 under President Obama. In addition to teaching international law, human rights, and national security courses at Howard, Darin also serves as a senior legal advisor at the PILPG, and Darin was just named to the, Darin, you're going to have to help me with the title, to the International Law Advisory.
To the U.S. State Department Advisory Committee on International Law.
So congratulations, Darin. And a fun fact about Darin is that he's an avid comic book fan and has been collecting Marvel comics since he was young. He's also a Trekkie, Michael, and has seen every live-action Star Trek movie and TV series. And last but certainly not least, Alex Cuic. Alex Cuic is a partner at the Robert Brown Immigration Law Firm in Cleveland and also an adjunct professor and director of the Immigration Law Clinic at Case Western Law School. He received his JD from from my institution, the Cleveland Marshall School of Law. He also received a master's in business administration from Cleveland State University College of Business. Alex oversees the firm's litigation practice, focusing largely on removal and deportation defense matters and general litigation, and he's also well versed in the firm's family-based immigration practice. Alex is a graduate of Bowling Green State University, where he majored in international business and Russian language and culture. And prior to his arrival at Robert Brown, his current law firm, Alex was a solo practitioner working in the field of general litigation and legal ethics. And a fun fact about Alex is that he loves to smoke meat. He is a meat smoker, and it's a hobby that he enjoys with his father. Okay, so we're going to start. The first question goes to Paul. So, Paul, the firm you founded with Dean Michael Scharf 25 years ago, the Public International Law and Policy Group, was born out of a desire of legal scholars to provide their advice and legal acumen to parties around the world on a pro bono basis. Can you discuss how PILPG harnessed the power of the Academy during the early years and how that relationship has evolved over time?
Sure. But first, Milena, you're a fun fact.
Oh, wow. Put me in. Fun fact, I have an identical twin sister who, if she took my spot at the podium, you guys would never know. So,
And she may actually have taken your spot. Thank you for your question, Milena. This gives me a chance to spend 2 or 3 minutes on the origin story of PILPG. And the origin story is titled Old Speckled Hen. And we'll get to in a second why it's titled Old Speckled Hen. And no, I have not been drinking Old Speckled Hens. It's just a mouthful to pronounce. When I was at Cambridge, I had left the Department of State, and I was writing op-eds and the modern day version of blog posting and whatnot. And the Bosnians reached out to me and said, would you like to come to Dayton, Ohio, at the Wright-Patterson Air Base and be our legal advisor, our lawyer, during the peace negotiations? And I was like, sure, sounds like fun, but don't you have lawyers? And it's like, we have tons of lawyers. We've just never done peace negotiations before. We've never negotiated ceasefires, power sharing arrangements, transitional justice arrangements. So why don't you pop out to Dayton? And while I was there, on my way, I called Michael and I said, Mike, guess what? I'm going to Dayton, and you're going to help me help the Bosnians negotiate the Dayton Peace Accords. And Mike, can you call a few friends as well? Because we might need a lot of help. And so while I was at Dayton, Michael was in Boston and organizing a number of former Department of State lawyers. Mike and I had spent time in the legal office before heading off to academia. And after I left the Dayton Accords, I went back to London, and the Macedonian ambassador, and now we can say the North Macedonian ambassador, bumped into me at a reception at a Croatian National Day reception and said, we'd love to have you and your firm provide some advice to President Gligorov on our negotiations with the Greeks. So I called Michael and I said, Michael, guess what? We have a firm. And he's like, we do? And I'm like, yes, us and our friends who are in academia. And my wife at the time was working for Accenture, and we had a flat in Windsor, and across the street was the Round Hill Pub, which served Old Speckled Hen. And we went for a pint or two or three, and we spent the evening discussing how we could create a global pro bono law firm. And my wife had 2 pieces of advice, well, 3 pieces. She said, call Michael, call your other friends, call Drew, get Drew to be your strategic advisor, do it for free because you're 29 years old and no one's really going to pay you to do peace negotiations and post-conflict transitional justice, and come up with a really long name that no one can really remember but sounds serious, hence Public International Law and Policy Group. And what we realized is that there were so many academicians at Cambridge University and other universities in the UK that were looking to launch a career teaching, but also wanting to practice international law. And I think Darin will talk some more about that as well, the praxis of peace. And then secondly, that there was this cadre of former Foreign Office or State Department lawyers who moved into academia and really missed practicing public international law. And so over the last quarter or century, Mike and Drew and Darin and Milena and I have worked to basically harness this intense intellectual power that Mike Newton and others were talking about this morning to basically do peace talks, post-conflict constitutions, and prosecuting war criminals. So that's our origin story.
Yes, and I am, as Paul mentioned, Darin, Drew, and I have all been heavily involved with the PILPG over the years, and it is truly a wonderful organization. So a little plug for the PILPG. Paul, in addition to running the PILPG, you also run the renowned Lawyering Peace Program at American University's Washington College of Law, where you teach and train the next generation of public international lawyers and policymakers. How do you foresee the intersection of academia and the pursuit of peace and human rights evolving in the coming decade when your students help lead the field?
We can all retire in the coming decade. One of the things that the advantages of doing this type of practicing of public international law from the academy is that you can train the next generation. Everyone talks about the next generation. And we all have had these conversations. You say the word millennial, and I know what you're all thinking. There's this whole sort of, collage of ideas and thoughts. But one of the opportunities as an academic is to be able to help to train and to shape and develop the skills, or at least identify the skills that these young professionals might be interested in developing so that they can have their impact on the world in the way that they see best to have that impact. There's a huge interest, as we all know, and we'll hear about from our colleague Alex on the Immigration Clinic, real practical skills. And if you can teach students practical skills while you're helping them negotiate ceasefires for clients, or they're helping you draft ceasefires for clients, and Jim Johnson talked about it this morning as well, having those interns, having those stagiaires, those students helping to basically do real world work out there that makes an impact, but developing skills that can transfer to a firm, to the State Department, to another foreign ministry. What I love about LinkedIn is you can track your web of influence. There's 900, between Michael, Milena, myself, Darin, we have 900 alumni out there that have gone through some form of Lawyering Peace, or the Yemen Accountability Project, or the work that Milena does at Cleveland Marshall. And you can sit back and see that amplifying effect of just a half a dozen professors, but over the years continuing to build that skill set and that network of students, and then they network on the network on the network. It's like that old Fabergé commercial. They tell two friends and they tell two friends. And so that's one of the things that we all bought into early on, building that cohort, building that cadre of young professionals that will then go out and make the world a better place, however they see fit.
Thanks, Paul. The next question is for Darin. Darin, can you talk a little bit about the interplay between academic theory and the practice in the peace and human rights space? How has this interplay manifested in your own work at the State Department, at the White House, or also at the PILPG?
Great. Thank you so much, Milena. And if I could just take a point of privilege to thank Dean Scharf for the wonderful opportunity to be here celebrating the Cox Center's 30th anniversary and PILPG's 25th. And thank as well Paul Williams for the invitation. I also wanted to just take a moment to reflect on, for me personally, how wonderful it is to be here at Case Western. I actually have a familial link to the institution. My maternal great-grandfather, a century ago, in 1919, left Georgia to come to what was then Case Institute of Technology to study chemistry before returning back home and marrying my great-grandmother and starting our family. So it's kind of a full circle moment for me to be here at Case Western, knowing that he was just here a century ago studying. So I wanted to just acknowledge him in this moment. Milena, to return to your question, you asked about the interplay between academic theory and practice in the peace and human rights space. And we've heard a lot about this interplay between academic theory and practice from the various panels that have been held today. But I'd like to just take a moment to focus on the deep body of scholarship that academics have produced over the last several decades, right, in the fields of peace building, human rights, and transitional justice. And in particular, as it relates to the work of PILPG and some of the work that I'll mention that I've been engaged in, international scholars have really developed some very advanced, intricate theories on best practices, right, in areas such as peace negotiation, best practices in the field of post-conflict constitution making and constitutional design, as well as human rights accountability. And as Paul mentioned, I like to refer to these applicable theories as contributing to the praxis of peace, right, or the practice of peace, the work that many folks at PILPG and other practitioners are engaged in the field. Milena, you asked a bit about how these theories and this interplay between academic theory and practice has related to my own work. And so, I'll just touch on my own introduction to this field. Milena mentioned, while I was at the State Department, I spent a year serving as legal advisor in Baghdad, our embassy legal advisor. And it was actually in that capacity that I really started to become engaged in issues involving post-conflict transitional justice, right? One of our embassy responsibilities was to help the Iraqi citizens to stand up new legislative mechanisms implementing new provisions within their reform constitution, right? And so I was very deeply enmeshed in issues such as electoral reform, vetting, de-Baathification, how the international criminal accountability would be addressed domestically. And so as we were working on these issues within the embassy, we drew largely from the scholarship, right, that other scholars had produced in similar contexts. And the same thing happened later, right? In my time when I returned to the State Department, I had the privilege of serving as a senior official in an office that was stood up specifically to support the Arab Spring transitions, right? And so a significant part of that support was supporting the constitutional reform processes that were unfolding in a number of those countries. And again, we drew from the scholarship and the great scholarly work that had been done around questions of constitutional reform in post-conflict environments. And the interplay that, I myself have had the privilege of seeing, both at the State Department and then later at PILPG, where Paul, Milena, and I and Drew have, had the opportunity to work on so many exciting issues, and Michael, as well as including issues such as the peace process in Sudan, right? And so in all of these efforts, we're drawing from these best practices, and the interplay becomes exciting because not only are we drawing from these best practices, right, but as scholars and practitioners, we're drawing from the experiences that we have in the field, and our experiences are going back into the body of scholarly work that contributes to the praxis of peace. So there's this very synergistic interplay between application of these theories and practice, and then transformation and evolution of the theories through the scholarly work of many associated with PILPG.
Thank you, Darin. And we will return to this theme of the interplay between theory and practice, and we'll talk a little bit more about the work of the PILPG as well. But I wanted to turn to Drew next. So, Drew, you've long been engaged with the work of the PILPG, most recently as its strategic advisor. In 2018, you were a senior legal advisor to PILPG's Rohingya documentation mission in Cox's Bazar in Bangladesh. The U.S. government funded and guided the project in order to understand what happened to the Rohingya and to make a determination of whether policy action should be taken. Can you speak a bit about the methodology used when documenting these atrocities, particularly the approach you and the team took when dealing with sexual and gender-based violence?
Thank you, Milena. Thank you, Milena. First of all, just a brief recap of what was happening to the Rohingya in mid-2016. The government started to increase actions against the Muslim minority in the North Rakhine state on the southwest border of Myanmar, Burma, adjacent to Bangladesh. This started refugee flows. There were extreme abuses and whatnot, driving people out of their homes. It exacerbated after a insurgents attack in August 2017 to the point where hundreds of thousands of Rohingya left their home and moved to camps in Bangladesh. Cox's Bazar area. The State Department decided to fund a study to find out exactly what had happened. In order to make a study, to conduct a study that was objective, credible, neutral, and transparent, and one that would withstand claims of cherry-picking stories and bias, the State Department, along with PILPG, developed a methodology in order to obtain the information, conduct interviews, and do an assessment of the information that was received. The methodology is very important in order for the report and its conclusions to be credible. In fact, they were key for the State Department to be able to make some determination about what had occurred in Burma at the time of these actions, as well as providing information and support for subsequent determinations and efforts by the International Criminal Court and the U.S. Human Rights Council. So the purpose was to get an accurate understanding of what had happened in Myanmar. And in order to be able to sort out any patterns that would be able to justify a finding of serious human rights abuses. In order to do that, PILPG, along with the State Department, happened on and developed a methodology which entailed the use of experienced investigators. We ultimately found 18 international investigators, 18 from 11 countries around the world, which ensured gender and regional geographic diversity. We used those investigators to ensure that they would conduct randomly selected individuals throughout the camps in Cox's Bazar. There are over 40 camps and settlement areas in Cox's Bazar. Ultimately, the 18 investigators were able to cover 34 interview in 34 of the 40 places. We used modern polling and statistical techniques such as skip patterns so that you would make sure that the investigators' paths did not cross, so you did not cover the same people. We ensured skip patterns to make sure that a wide range of areas were covered. We would go into a household. We would ask permission to conduct the interview. We would get confirmation of an informed consent by the household. We would then use a polling sampling called random birth date to be able to select the person within the household we would talk to, because oftentimes it would be the senior male who would want to talk to us, or the person who had the good story. Well, that would not ensure a random selection and a credible basis for drawing conclusions. So we used the random birthday selection. We were only talking to people over the age of 18 in order to ensure that the informed consent would not involve young people. We were talking to people who had only left Myanmar, fled Myanmar, after October of 2016. There had been successive waves of Myanmar refugees staying in Bangladesh. They go back at least to 1992. We were seeking only firsthand accounts. It wasn't good enough for somebody to say, well, I heard my next door neighbor say. We were only looking for firsthand accounts. We were not going to document hearsay. We were using a standardized interview format, a questionnaire that had been refined over a number of years, so that we would be able to elicit information that would allow us to draw conclusions. And at the end of each day, we would code. We would take the information that was received, and we would try and break it up into perpetrators, victims, witnesses, events, what had happened, the location, and all of those would be identified by a number, given a code, which would then make it easy to ultimately process the information. And it was by coding and looking at the information in an aggregate that we were able to discern various patterns of serious human rights abuses. That's generally the methodology that we used. As for sexual and gender-based violence, this was an overwhelming concern because we were aware from media and NGO reports within the camp that serious violations of these sorts had occurred. The interviewers who were selected obviously were experienced in terrible traumas and so brought an awareness of how to deal with individuals who had received and been the victims of such violence. We ensured there was gender diversity in the interviewing team. We had just over 50% of our interviewers were female. We had an overwhelming number of female interpreters. And so we ensured that every team that went out had at least one female interpreter and or one female investigator in order to make sure that gender considerations were taken care of. We tried to prepare both the interpreters and the investigators during the investigation, during the training, of what to expect and how to handle issues of SGBV during an interview. We also provided socio-psycho support both to the interviewers and the interpreters to ensure they retained awareness and they knew how to deal with these sorts of incidents as they came up. We also had each investigator be aware of the resources that were available within the camps for social, human, medical, psychological care, so that we wanted to minimize any re-victimization that had occurred by the people we interviewed. With all of that, we were aware that even with the large number of incidents we were able to get from the witnesses and the victims, we were probably still underreporting the information. The questionnaire we had in that sense was a little bit rigid and did not permit enough of follow-up questions and getting additional information to allow us to make a full examination of that project. But still, I think we were able to bring together sufficient information to make claims that serious crimes had been committed involving sexual and gender-based violence.
Drew, follow-up question to you. Ultimately, the PILPG drafted and issued a report called Documenting Atrocity Crimes Committed Against the Rohingya in Myanmar's Rakhine State, in which, and in that report, the PILPG concluded that there was credible evidence that serious violations had been committed against the Rohingya ethnic group in Myanmar. What kind of this is a question for you, Drew. What kind of a role do you see that report as playing? And also, what do you think of the U.S. government's response or lack thereof since the report's release, which was a few years ago now?
Right, 2018, the report was released. First of all, the report itself was brought about by an intersection of exactly the academe, the legal professionals, the legal practitioners, the government. It was an accumulation of all of their efforts. The process and methodology was created by PILPG and the U.S. government. It was implemented by people who were involved with NGOs and legal practitioners. The report was developed by NGOs, academics, legal practitioners, and of course, it ultimately went to the government for its own policy considerations and its own determination. And through publicity and continued outreach we were able to engage academics and the media and governments in order to heighten awareness of what had happened and hopefully influence people's actions and government policies. So the report itself was able to bring together exactly the sort of policy groups that can influence human rights and tried to give them direction for them in order to address what had happened against the Rohingya. As for the United States government's response, remember the report itself was funded and was the methodology developed by the United States government. So in effect, the United States government did a remarkable job. This was during the sort of the beginning, middle of the Trump administration. So we need to remember that they made a significant contribution to raising awareness as well as highlighting the abuses that had occurred. This wasn't the first time there had been significant documentation of human rights abuses by the United States government. Of course, there's the annual Human Rights Report, which every embassy in the world contributes to. There was also in the 1992 and 1993 Yugoslav conflict, effort by embassy officials and refugee officers around the world, but primarily in Europe, to collect statements of people who had suffered during that conflict, which were then provided to the UN's Commission of Experts, which ultimately formed the basis for the information that was passed to the Yugoslav War Crimes Tribunal. And one of my jobs when I was there was to help lead a team to sift through the information to be able to develop initial case files so that we knew whom we should start targeting with our investigation and prosecutions. And then in 2004, there was an effort by the State Department to fund a mission very much like the Rohingya mission to look at what had happened in Darfur. This ultimately led to a report which influenced Secretary Powell when he decided to identify what it was happening in Darfur as genocide. In 2011, the State Department also funded a study involving what was happening in South Sudan. That mission was cut short, and Secretary Clinton used the findings, the incomplete findings, for her private diplomacy. She didn't choose to make it public. So in 2008, the Rohingya report and the Rohingya mission was done at the behest of the United States government. We also had Ambassador Brownback, the ambassador for religious freedom, visit the camps, talk with the investigation team, and use a press conference to address what had happened there. There was an official reaction by the United States government. The Treasury in August of 2018 sanctioned 4 military commanders and 2 military units. Based on the findings of the report, the State Department issued its analysis of the data we had collected and called into question serious human rights abuses that had occurred. It does, however, fall short. My understanding is there was a memo sent up to Secretary of State, to Pompeo, to make a determination of crimes against humanity occurring against the Rohingya. Unfortunately, Politico in late August of 2018 leaked that the memo was in front of Pompeo, and reportedly in a fit of pique, because his news had been leaked and he wasn't going to be able to make a significant announcement, he decided not to make the determination, and ultimately the report that did come out by the State Department did not make a determination about crimes against humanity, genocide, or war crimes. So it didn't go far enough, but the emphasis is there, and I believe the current administration, the Biden administration, is reviewing the findings of the Rohingya mission and is struggling whether they want to reinvigorate an examination of it and whether they are going to make those calls.
Thank you. Now, I do have several questions for Alex as well about his practice in the immigration area. But before we move on to immigration, I wanted to give Paul and Darin the opportunity to weigh in. I see that Paul is writing notes furiously. So, Paul, why don't you start?
Thank you, Milena. No, I just wanted to weigh in on this notion of lawyers having an impact on public policy, and it's one of the things that I've been surprised by. I grew up in Silicon Valley, and if you're calling the lawyers, it meant there was a contract dispute, there was a real estate dispute, there was some issue. But in Washington, D.C., and in the practice that we've developed globally, I've been very surprised that our clients, our pro bono clients, will ask, well, what's the legal basis? Or if we're working, testifying on the Hill, or engaging in other type of public advocacy, engaging with the journalist, what's the legal basis? What are the legal requirements of a crime against humanity? Or what is the legal obligation to prosecute individuals? Or what legal authority does the Security Council? And it's very surprising because we oftentimes, when I'm working with my young professional team, they'll hear a lot of, international law, is it really law, et cetera, et cetera. But out there in the quote-unquote real world, the clients, the governments, those negotiating peace agreements, those setting up tribunals, are deeply interested in what the law is. And this is something that Mike Newton said early this morning, which is useful for people to keep in their heads, for young professionals as they go through their careers. Lawyers don't make the law. They advise and assist others who may then make the law, make treaties, engage in state practice. And Mike was very honest. You know, if you're working for a client, you shape and you interpret the law. But if you've got clients on all sides shaping and interpreting, then you can get a full picture of what the law looks like. And as an academician, writing those law review articles, Ali, that none of your fellow students want to write, is all about articulating what the law is and what the law could be. And I've been very surprised in a refreshing way, working with the pro bono clients, that they really want to know what the law is. And then that gives them the extra spring in their step or the extra quiver in their arrow in their quiver for their policy making, policy shaping arguments. And so I've learned to not underestimate the power of the law and to not underestimate the obligation to accurately articulate the law before you start trying to shape it or evolve it.
Yeah, and actually this one is for the students, but I'm going to jump in real quick here. Paul and I once talked about this, and Paul said to me, you know, for our students, the value added as a lawyer is that we actually read the documents. You know, so to know what the law is, you actually have to read the treaty, or you have to read the UN Charter, or you have to read some policy memo. So our value added is that we actually read the documents, in addition to many other things, right?
Looking at you, Drew, the diplomat.
Darin, would you like to weigh in?
Yeah, I just, you know, it's interesting in thinking about this question of the role of lawyers, right? And the role of lawyers in working with policy clients or pro bono clients. I think an interesting analogy when we think about the work of practitioners in this space, where practice, right, and, you know, different scenarios help to shape our understanding of the law is implemented. You know, I think as law students, you know, you can almost think about this engagement between practice and scholarship is almost building our own bodies of common law, right? So you're often in the classroom and you see how case to case, with just a slight change in facts, you know, the law evolves. And so when we're thinking about this praxis of peace, right, and how these theories of constitutional design or constitution making or negotiation of peace agreements, they really build on practice, right, and the stories of what evolves in a particular context, right? So what happened in the Dayton Peace Accords may be slightly different than what happened in the Comprehensive Peace Agreement in Sudan, or what happened in the constitution-making process in Egypt is going to be a little bit different than the constitution-making process in Tunisia. And so as scholars and as practitioners, each time you write about these incidents, right, you're building kind of this broader body of common law, right, of the praxis of peace. And I think that's one of the really exciting things that practitioners in this space get to do. And to link it back to what Paul says, that's what the clients are looking for, right? They're really looking for you to be knowledgeable about the best practice in the field. And as practitioners, we can play a very important role in feeding back into that evolving understanding of the law. I just want to mention a couple of areas in which folks affiliated with PILPG have done just that. So Milena mentioned earlier a book that she, Michael Scharf, and Paul all co-authored on the Syrian conflict, right, and the impact that the Syrian conflict had on our understandings of international law, right? That's building to this broader understanding of the praxis of peace. PILPG last year put out a research handbook on post-conflict state building, right, informed by various contributions from folks in PILPG and otherwise. And so we've got this great body of scholars who are constantly doing this work and taking best practices from their work and contributing to this broader common law of the praxis of peace.
Go ahead, Drew.
You also have to realize the policymakers, the people you're going to be talking to, hopefully you're going to be influenced, they don't have the time to have devoted the attention to the issue that you will. If you'll get in to see a senior official, you might have 15 minutes, you might have a half hour to deal with a particular point of view. There'll be other people involved there. They may have different points of view. And the senior policymaker is going to need to hear from those of you with specific information and specific knowledge to be able to draw on that information to help this person, the policymaker, make the decision. So it's going to behoove you, as they say, to read the documents, to make sure you have all of the information, because quite frankly, the policymaker won't have time to have done all of that.
Thank you. Now, one of the important policy issues right now is immigration. And so for the next 3 or 4 questions, I'm going to go to Alex and ask him about his practice as an adjunct professor of law, the director of immigration, of the immigration clinic here at Case Law School, and also his experience as an immigration law practitioner. Alex, how has your experience as a professor and clinic director shaped your legal practice? Or, would it be more accurate to say that your legal practice has shaped the way that you approach working with students?
Yeah, so thanks you everyone for being here. I would say they've impacted each other. When I was asked to start working in the clinic and take it over, I didn't know how to, admittedly, I'm the least academic of everyone up here, right? But I've been practicing immigration law, for over 16 years. So I know immigration law. I am a partner at a firm here in Cleveland. We have offices in 4 other cities, and I run the Cleveland office. So I know how to run an office. I know how to train attorneys. I don't know how to be a professor by any stretch of the imagination. So when I came in to kind of take over the clinic, my theory, or at least my idea was, when you're running a clinic, you're teaching, run it like a law firm, right? Immigration law, think about it like a 3-legged stool. There's family immigration law, which consists of asylum law, refugee law, citizenship, green cards. There's employment immigration. You're bringing over scientists, engineers, athletes. I do a lot of rock band tours, so fun stuff like that. And then there's deportation defense, people being removed from the United States and appearing in front of the immigration courts. And so you take this 3-legged stool and you want to apply it to an immigration clinic at a law school. How do you kind of develop that? So when I took over, if I remember right, it was February 2016. I think we had 4 or 5 cases. Professor Cover actually hired me. So we had like 4 or 5 cases. And immigration law is a very, very high volume practice. In my practice now, I probably have over 500, 600 cases under my belt right now, right? But to the extent it's high volume, it's kind of a hurry up and wait. Get everything filed, meet your deadlines, and then you kind of go into the slow immigration process, however long it takes. So when I say it's high volume, it is high volume, but a lot of these cases take a long time to get done. So happily to say, like last semester, I think we represented 27 clients in our clinic. And these are people who are, low income, unable to get legal representation, people who are detained. It's important, right? And as we talk about this whole human rights thing, we might maybe questions later about kind of how this immigration court system is set up, right? You have a huge swath of people who are unrepresented here. And, my background was in ethics before I became an immigration attorney, and immigration law has a horrible reputation for really bad lawyering. And so that's another kind of thing I wanted to teach these students is, I always tell them the story that when I first started practicing, I had this guy came into my office and offered me $50,000 cash to make up an asylum statement for him. And I always remember this, and I was like, that's a lot of money. I got these student loans I got to pay. I think, admittedly, it crossed my mind, that's a lot of money, right? But you can't, right? You guys are, those of you who are students here, you're working so hard to get to this point, and you can lose your reputation and everything like that, right? And so these are the kind of I don't want to say those things, but these are the kind of the aspects I brought to a clinic was to run it like this. Has it impacted me vice versa? It has. I will say that I have, when you are teaching, I guess the best part of teaching is you're teaching yourself kind of over and over what you already know. One of my roles as a partner is I also train our attorneys when we send them off to another city, or if they stay in Cleveland, I train them. And I think this kind of role that I've actually developed here at Case Western has really, really changed my ability to actually train newer attorneys. And they were bringing up earlier, the next generation, right? Not saying that my way is the best way to do it, but I think it's it's better than most. So.
Great. Now, as you mentioned, you've practiced exclusively in immigration law for over 16 years, focusing a lot on removal defense in immigration courts. For those individuals that the U.S. government seeks to remove from the United States, what issues, be it basic safeguards or fundamental fairness, do you see in the immigration court system in the United States?
Yeah, so to kind of give you a little bit of background or kind of a 20,000-foot view of immigration court, it's not a real court. When we call it a court, it's a court by name, but it's not really a court. It's a court that is a non-independent court that falls under the Department of Justice. So you have the Attorney General, you have the Department of Justice, you have a division called the Executive Office Immigration Review, EOIR, that is the immigration court system. Underneath that, you have essentially two levels of courts. You have immigration judges, and you have an appellate court. During the Trump administration, for example, they hired, I want to say 185 judges around the country, and like 90% of them were former ICE prosecutors, or they were attorneys for the U.S. government and the military. Those ICE prosecutors, the chief judge of the immigration court system was the head of ICE, their legal division, and his deputy was the assistant chief judge. So essentially you took one party in this proceedings, you made their two leaders the head of a court system, and then you kind of filled in the gaps in the next attorneys. The immigration court system is seriously flawed in that it is designed for the person being removed to fail. There's no right to counsel. So you have no legal right to counsel. There are no, federal pro bono groups that are able to help people. You do have a right to an interpreter, assuming they can find one. So let's say you speak, Mum, and there aren't many Mum speakers around here who can kind of show up and interpret, and you're detained, you're going to stay detained until they find an interpreter. We have something in immigration law called mandatory detention. So something small as, I'm not trying to limit or belittle this conviction, but something as small as drug paraphernalia will render you mandatory detention, irrespective of your family background, your family plight, any issues you have. You sit in jail the entire time. And if you don't have an attorney, you're going forward and fighting for yourself. So you have these issues like this. You have a lack of immigration attorneys. I mean, there really is. There's not very many. It's a very small kind of niche group. And you have these court systems. I think we have 55 immigration courts around the country. When the Trump administration started, there was a backlog of 535,000. They hired 100-some judges, and we have a backlog of 1.2 million now. So by hiring more judges, you have a bigger backlog. You have a court system that has detention facilities essentially built in that are run by private enterprises. You can buy stock in, the two big jails that are running all the immigration facilities. I mean, they're publicly traded companies. So a lack of representation, a lack of fundamental fairness, and you have judges. The University of Syracuse does a report called Track. It comes out every year, and it ranks all these immigration judges around the country. We have a judge in Cleveland who got transferred here from Houston who has denied 100% of his asylum cases over the past 3 years. It's incredible, right? I mean, 100%. Why bother going to court? Right at that point, you're going to get denied. Cleveland, the easiest judge denies 82%. Like, you pull that judge, you're like, wow, I got an 18% chance to win. This is great. So think about that system. What other court system do you have that? And I think the biggest flaw is the lack of independence in the immigration court system, is that the attorney general runs the immigration court system like a dictatorship. So to give you an example, essentially what they can do is, in a normal court, you have precedent. You have years of court precedent. You have lower court level, you have a circuit level, and you have Supreme Court making decisions. Immigration court, we have that too, right? We have the immigration court, and we have an appellate court that makes decisions. An attorney general can come in and just say, I don't like this precedent, I'm changing it. Jeff Sessions did it like 7 times his first few months as an attorney general. And essentially there's a case called Matter of ARCG, which was a asylum-based claim saying that women who are victims of domestic violence and who are unable to leave the relationship are what's called a particular social group for purpose of asylum. It took forever to get to this point. 2016, Jeff Sessions comes in and is like, no, we're not doing this anymore. And by a written decision, stripped it away. 2 months ago, Attorney General Garland is like, we're going to go back to the old way it was. So while it helps us as practitioners, we like this, right? We want to go back to the way it was before. Do we really want a system where however the kind of political winds change, we have someone going in there and just stripping precedent from one way or the other? And it's actually happened. It's done, Garland has already stripped away, I think, 4 cases, if I remember right, that Sessions overturned, which are precedent before. So it's kind of going, this is back and forth. So the lack of independence, they talk about a broken immigration system, it's shattered. And the court system's shattered, and it's, for all the court packing talk that we heard during the elections, they hired 90% of all their judges are, ICE prosecutors who are going to be working for judges now.
Wow. Earlier in the day, we were, struggling to find some positive themes and optimism. I get a sense we're not going to get any when we talk about immigration. No. But thank you so much for that insight. Alex, one more question for you. Under the Trump administration, it was well documented that immigration, both legal and illegal, was a focus. What do you envision the Biden administration will do with some of these Trump-era policies and rules going forward?
Yeah, so like I mentioned, Attorney General Garland has revoked several precedent decisions. That's the start. I think the Biden administration is tied in a way that the Trump administration was tied the same way. Was immigration law has been fundamentally the same since 1997 during the last passage of the IRA. It's the last immigration kind of reform we've had. And that one was based on the 1990 Reform Act. So really, immigration law hasn't changed much in 31 years. And so what can the Biden administration do? Alone, not much, right? I mean, they can replace, they've already replaced the head of EOIR. They've already, obviously, have a new attorney general. So those policies can change, but fundamental or, big reform is not going to happen without Congress. I mean, it's ultimately going to come down to Congress. There's obviously policy they can do. I mean, there's a border policy right now that's, up to debate whether or not it's the proper policy or not. But that policies like that can happen and they can impact it. But a fundamental change is not going to happen under the Biden administration. It's not going to happen under any administration unless Congress gets involved.
Yeah, and actually, one last question for you, Alex, and warning, this is off script. But I recently listened to an NPR program where one of the panelists talked about how one of the fundamental flaws of the U.S. immigration policy is that we tend to view migration as a general matter as a problem. Whereas if we approach it not as a problem, but as a normal state of affairs, because if you think about it, the U.S., for example, attracts and retains a migratory workforce. There are only migrants working in certain fields. And so in a way, our economy depends on their presence here. So what do you think about, a migration approach that wouldn't view it as a problem, but would rather view it as, an issue to be approached and sort of solved, but not as a problem?
Yeah, or like a solution, right? I mean, I can give you an example for like employers. Think about like the restaurant industry, right? They call us all the time. They're like, hey, I got this chef. I need them to bring him to the United States because I can't find a chef to work here in the United States. Great. It's going to take about 2.5 years to get him here. Can you wait 2.5 years? No, we need a cook now. So the system is really set up to be this delayed, and it is designed in a way to help the American worker, right? I mean, especially when you're doing kind of green cards based on that. But yeah, if you look at it as a problem solver as opposed to a problem, yeah, there is. I mean, it's just how the system's set up is that we are we've always been restrictive to immigration. And we've had quotas, we've had refugee quotas. We actually have nationality quotas. It's funny. In my class on Thursday, we were talking about something called the Priority Day in a Visa Bulletin. If you were to file for an application for your brother and sister, and you're from wherever, United Kingdom, about a 13-year wait to get them here. You're from the Philippines or Mexico, about 30 years, 20 years. I mean, it really depends on your country. So there's a quota system. I mean, we have a system that's designed to keep people out of the United States. And historically, we've had this before. We had something called the Chinese Exclusion Act, where we didn't want Chinese people to come to the United States. And we had an Irish Act like that. We've had all these acts to exclude people. It's always been a system historically to keep people out as opposed to bring them in.
Yeah, India, I hear also there's
India is for Indians who are coming to the United States to work. Or based on their education and background, there's the way the system's set up is we have a lot of them coming in, so we want to give everyone else a chance. And whether that's fair, that it's not fixing the problem, right? The employer doesn't really necessarily care about their nationality or background. They just need the best qualified people.
Thank you. I'm going to ask one last question of our panelists. In the meantime, if you have questions, you can start formulating them, in your heads. And if you want, you can come up to the microphones. There's one microphone here and one microphone over here. So you can start getting ready for questions. So here's my last question to the panelists. So in law school, we learn all these concepts. So for those of us who are in international law, human rights, you take a class, you take a class on international law, you take a class on, post-conflict constitutions, human rights. But what does it really look like when you're in the field? So, Paul, let me start with you. Can you just share a little bit about, you and I just recently went to Juba to facilitate peace negotiations between Sudan and one of the rebel groups. What does it look like in the field? It's certainly very different from anything you've learned in the classroom, but what does it look like in the field?
It's dusty.
Lots of mosquitoes too, right?
Lots of mosquitoes in Juba. No, I'm glad you asked that question, Milena, because the field could be Geneva. At the Peace Palace. It could be the Rambouillet Chateau outside of Versailles. It could be Juba. It could be Mike and I spent some time together in Tripoli and Misrata and Benghazi. We've also done work in Yemen in Sana'a, Sada, Taiz, and Aden. And young professionals thinking about doing international law and getting into the field, it might be London, Paris, Geneva, but it's likely to be, as my South Sudanese friends always say, in the bush, and lawyering in the bush, so to speak. And we use the phrase of putting briefcases on the ground or getting dust on our briefcases. And what you find in the field is there's an intense time and place for law, but it fits in with all of the other moving pieces of negotiating a ceasefire, negotiating a post-conflict constitution, negotiating a power-sharing arrangement. And when you're in law school, you're 24/7 law, or when you're in a law firm practice, and we do a lot of pro bono work with a lot of law firms do voluntarily pro bono work for us, is 24/7 law. And when you go into the field, a lot of politics, a lot of violence, a lot of military strategy. And then the moment when they turn and say, okay, now we're going to put that in writing. And one of the things, we have a ceasefire negotiators handbook, and it was a picture that was taken in Doha during the ceasefire negotiations. And there's a room full of our clients, the Darfur, one of the Darfur non-state armed actors. And we were preparing to go into the ceasefire negotiations. And we're all there. And then there was me with my laptop open. And this is one of the value adds. As Milena said, reading the documents is a value add because everyone knows what the Security Council resolution says or what the previous agreement said, but they read it a really long time ago. The other value add that young professionals, young lawyers have is distilling the debate, the argument, the fierce political bargaining into words. And this was referenced earlier today that Mike Scharf and Mike Newton in Uganda working on the PILPG project for the war crimes creation, the clients get used to sharing all of their thoughts and ideas and positions, and then the lawyers distill it into something. That's what I was distilling Drew's comments into something. They distill it into something that then you give back to your client, and they're like, yeah, that's what we said. That's what we want to put on the table. And, thanks for putting a few options in here. We're going to cross that one out. We're going to take this. I had one client, Montenegro, working with Montenegro on the union treaty negotiations with Serbia. And I listed off 4 options. And I did this on purpose. And when I gave it to the chair said, Professor, we have 4 options here, but we only have 1 delegation. And I'm like, yeah, your delegation has 4 options they want to present to the Serbian delegation. He's like, we are not doing that. We are picking 1 option because we're 1 delegation. But they hadn't sort of realized that in their conversation. They all sort of retired for the evening thinking, we'd sorted out our position tomorrow that we're going to put on the table for the Serbian delegation. But they really hadn't sorted it out. And it took that skill of a lawyer, which is a simple skill, to identify, but a very difficult one to actually implement, which is to distill all these themes of the position into 1 document that they can pick and sign and then put on the table. And the last point I'll mention about being in the field, and it's about being in the field, but for the young professionals, it's value add for the rest of your life. Get your draft on top first. If it's litigation, if it's a corporate contract, if it's a ceasefire, put your client's draft on top first, and then they start working from that draft. When we were in Dayton with the Bosnians, we kept redrafting whatever it is that the internationals would put on the table. And Michael Wood, so we were here, Michael Wood came to us and said, "Are you going to do this every night?" And we're like, "Yeah, because we don't want the mediators to have the only draft on top. We want a Bosnian draft as well." And he was like, "Oh, this is going to take forever." But it was the idea of empowering the client by having their words on paper that they could point to as well.
And Paul, I think you'd agree with me on this one. So you want your draft on top, but if you're eating at the buffet, you don't want to take the top plate. You want to take the middle plate, because that top plate, you don't know how long it's been sitting there. And last thing you'd want is to get sick on, day one of peace negotiations. Drew, how about, some of your experiences from, the field? You worked at various U.S. embassies across the world. What does that look like?
Well, my experience was the U.S. government, the U.S. people were my clients. I was not a lawyer in the State Department except for 1 year when I took Paul's place in the European office during the Bosnian conflict. But I was there trying to bring the threads together when we had a particular issue, such as in Sri Lanka, with the change of the government in 2014, the Sri Lankans had been stonewalling efforts by the world to get them to address transitional justice mechanisms after the end of their civil war. They consistently refused to do so. The Human Rights Council was getting ready to sanction them. New government unexpectedly came in, and then it was drawing in all of the human rights work, drawing in the National Security Council, drawing in additional resources for development to encourage the new government to assist the UN Human Rights Council to reach a positive resolution. And they did. They agreed to certain steps to be undertaken in order to address underlying causes for the conflict and to promote transitional justice. So my experience was more working cooperatively with NGOs, with PILPG, for example, with USAID contractors when we were given a particular problem, drawing all of those people in to further U.S. government policy.
Thank you. Darin, you have also been, in the field as part of the U.S. government, but also on behalf of the PILPG. What has your experience been like?
Yeah, I'll share just a couple of war stories that I think touch on two key lessons that I've learned. The first key lesson actually parallels a comment made on the former panel, which is really that your clients or the individual that you're advising, they're trusting you and they're looking to you for your judgment, right? So your job is to not only be an expert, right, in the relevant area of the law, but your job is also to exercise excellent judgment. And that relates to the second theme, which is be prepared for anything. All right, be prepared for anything, particularly when you're in the field in some of these post-conflict environments. So the first war story, Milena, I'll share is kind of my first experience really being in the field and having a significant level of responsibility was in 2007. As I mentioned, I was sent off, as a young lawyer to be the embassy legal advisor in Baghdad. And so literally the day I landed on the ground was the day that Saddam's execution took place. It's a story that's extremely well detailed in Michael's book on Saddam's trial and the aftermath. And is noted in Mike's book, it was the execution was not carried out properly, right? And it resulted in kind of stories on the cover of the New York Times and in the press all around the world, and it fed this narrative, right, that had that existed among some, that the process of the trial of Saddam and his regime, who had undoubtedly committed extreme atrocities, that the process of accountability was really one of victor's justice, right? And that resulted from, a botched execution, right? And so that's what I stepped into, right? That was my first job as a young lawyer, was to help the embassy figure out, how to address this, right? And we came up with some steps. We halted executions. There was a lot of backdoor negotiation, and there was, some attempt to shore up the trial process that was taking place. But I had no idea that is what I would be walking into, and so it was this process of expecting anything, right? But also exercising judgment that helped to get me through that and some other incidents. And then the PILPG context is, as Milena mentioned, right? The process of working with some of our clients in Juba, right? During the negotiation of that peace agreement, and just realizing that, as a young lawyer, your job is to advise your client, but you can't always control the pace of the negotiation or the ultimate ability of your clients to reach resolution on issues. And so all you can do is provide your best judgment, and hope that they will trust you in the midst of these very complex processes.
And Alex, if you can walk us through, for you, the field is really immigration court, or perhaps, interviews before asylum officers if you're representing asylum clients. Walk us through, give us a snapshot of what an immigration case looks like. In particular, for example, if you're representing a client who the U.S. government wants removed, as you mentioned, what does that actually look like?
Well, it's it's different, right? No case is really the same. I can just give you an example. I had a case on someone bringing up about Bosnia earlier. I had a case I started in 2007 that ended this past Wednesday. So we've been fighting this case for 14 years. What's the process like? It's fundamentally unfair because the government controls everything, right? We don't have discovery in immigration court. Like you would in a regular court. We have Freedom of Information Act requests, which are heavily redacted. We don't have rules of evidence in our court. The government controls the entire court process. I mean, an immigration judge can't make a decision until the government says that person's background check's been cleared. So what does the process look like? That's what you're stacked up against, right? You're stacked up against lack of knowledge, lack of evidence, and you have a system where it can drag on for years. And you have people, in this case that we actually been fighting for all this time, it ended on Wednesday with my client halfway through like 7 hours of testimony going, I just want to get deported at this point. And he literally said, I'd rather die in my house back home than die inside of a courtroom. And he was just burned out. We've been waiting all this time, and then he was just like, that's how I'm ending this. Like, it was like a thud. You come back from court, I would fight this game, and that's literally how it ended. So, and I know you don't want to hear only bad news, you mentioned it before, but when you do win something, and when you do win an immigration court case, it's a great feeling, right? Because the odds are so stacked up against you and your client, and winning that is huge. And we had one, Dean Scharf and I were talking about before, we had this one in, give like a war story in a horrible situation. We had this case that we won on, it was April 20th of this year. She was from Trinidad. She left Trinidad because she was raped and had a forced abortion by her uncle in Trinidad. Comes to the United States as a visitor and is here for some time, meets a gentleman here, and they end up getting married, and he's like this horrible guy, and she ends up leaving him, right? She reunites with like a long-lost aunt in the Chicago area, and that aunt's husband sexually abuses her. So she finds refuge in a church in the Chicago area, and this family takes her in, and they're like, hey, we're going to help you, kind of get you on your feet, et cetera, et cetera. Sadly, that husband sexually abuses her. So everywhere she's going, she's getting sexually abused. And eventually, she's like, enough is enough. I'm not doing this anymore. And they said, okay. What they did is they drove her from Chicago, Illinois, to the Detroit-Windsor Bridge and dropped her off to Border Patrol and said, she's crazy. She's here illegally. She's causing havoc in our house, blah, 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 right? Border Patrol takes her in, and she's got no criminal history, do her background check, and they give her what's called a notice to appear. Go see an immigration judge, right? Your court case is in Detroit, right? Well, she's homeless, and she has no representation. She has nowhere to go, and she's got a court case coming up, and they mail it to the address that she gives them at these people's house. Well, guess who's not going to give her a hearing notice? This family who sexually abused her, right? So she misses her court date. When you miss your court date, you get deported on the spot. That's the situation. Judge shows up. You're not here. They order deportation on this gal. So she comes to us, and she's now married to an American citizen. She has a deportation order, so you have to try to reopen this immigration court case. And she's a child who has like serious health issues, like beyond serious. Comes to us, and we reopen her case in Detroit. Government objects to it, saying there's no hardship, and the facts and the circumstances aren't really like unique, is the words that they used. And eventually, a judge reopened it up in Detroit. We transferred the case down here in Cleveland, and she got her green card April 20th. We won the case finally. The students did everything. It was an awesome experience, right? But think about it, if she didn't have this representation, had immigration found her, you know what they would have done to her? They would have picked her up and they would put her on a plane and send her back to Trinidad, right? That's the system, how it's set up. So winning something like that, I'm sorry, like I feel like I'm making the room all horrible, but like winning something like that, that's what the whole point of it is. I mean, I think it's in every kind of area of law. You represent your client the best you can, right? And all you who are students here, I mean, like I was saying earlier, your reputation is what you have. And if you're honest with your client, you tell them, hey, these is what's stacked up against us. To me, that's the most important thing about being an attorney, is being brutally honest, not sugarcoating it, and telling them, hey, these are what we got. These are our options. We're going to do the best we can for you. And if it works out, it works out. But I don't know. Hopefully it's an uplifting story. She's won. She got a green card. She's here. Everyone's happy. And, she'll be a citizen 3 years from now.
Thank you. Again, I encourage you, if you have any questions, please come up to the microphone. But if not, I do want to end on a positive note, and that is actually a great story. Yes, no, that is, congratulations to you and your students for winning the case. I would like to ask our panelists, starting with Paul, to perhaps share a fun field story with us. I'm sure you have many, but if you can pick something, fun and uplifting, how about that? It's been a long day.
All right, a fun and uplifting story. When we were negotiating the Rambouillet negotiations, we had discovered the joy of compare documents and the joy of interacting with the news media. And the Kosovars had gotten their draft on top first, which was about 20 pages, and this was the draft that the internationals had agreed they would begin to work from. The Serbian delegation didn't really like most of what the Kosovars had proposed, and instead counter-proposed a four-page draft. We were a little punchy, we were a little bored, so we did a compare and contrast between the two documents, which showed line edits to those 4 pages, and then crossing out the other 12 pages. The Human Rights Annex, the Voting Annex, the Reform of the Police Annex. And then we happened to leave it on the table where the press corps would come in and pick up their press releases for the day as basically the counter proposal of the Serbian government. And then it got put out in the news that there was a counter proposal to basically cross out most of the human rights provisions. Now, of course, the Serbian delegation was completely bananas because they hadn't actually affirmatively proposed that. They just proposed a shorter proposal. But the Kosovars were interested in sort of shifting the momentum a little bit. So I don't know if it's a happy story, but it was certainly a fun story in terms of a way of kind of taking the underdog client, using a little compare and contrast with the 2 Word documents, and then getting it out to the media, who were a little bored after 10 or 11 days and wanted something to get out there and spice it up. And of course, they all looked at the lawyers because we were the ones who had the documents on our computers. We're like, what? Not sure what you're talking about. Thank you.
Drew?
Gosh, way back in 1997, 98, it was during the Sri Lankan Civil War, and a private had been picked up with a couple of other privates up in the north, where the Sri Lankan government military had recently retaken the Jaffna Peninsula from the Tamil Tigers, and there were quite a few disappearances. And there were rumblings of things that had happened, but nobody could find out what had happened. Well, he, in the midst of his trial, which was public, made the assertion that he knew where some mass graves were. And the government initially said, oh, that's fine, we'll investigate, don't worry. The United States government and the embassy decided to push. I had developed a friendly relationship with one of the young attorneys in the Attorney General's office. And so he had said, well, you're a good guy, Drew. We'll arrange to let you come up and observe what's going to happen, the exhumation. In the meantime, the United States government marshaled forces in order to provide international forensic pathologists to participate and help train the Sri Lankans in their exhumation. So I went to my other colleagues in the diplomatic community and said, you know, if they let me go, then they probably would have to let you go. So why don't we organize a sort of an effort for there to be a diplomatic representation during the entire time of the exhumation so that nothing untoward could happen, because there'll always be diplomatic eyeballs. And they were quite surprised, the Sri Lankans were quite surprised when the German embassy called up and said, well, we'd like to show up too. And then the Dutch embassy and the Canadian embassy and the Australian embassies. So we were able to ensure that there was sufficient oversight into what was going on. The United States government was able to provide additional training. Ultimately, the United States government provided DNA analysis after almost 10 years, but they were able to identify the remains of the 13 people who were uncovered. So that was a positive story.
Thanks. Darin?
Yes, I think just a nice success story from the field that comes to mind is the work that PILPG has been doing with our clients in Sudan for quite some time, right? Clients who had experienced the atrocities in Darfur, right, in the two areas and other parts of the country, and who had organized themselves politically, right, to participate in negotiations. And the fact that it was a people-led revolution, right, that finally toppled Bashir and created space for the peace agreement that was signed almost a year ago today. And it was just very powerful to see those same clients, you know, in the room negotiating peace, and to see, you know, women and others who had been victimized by Bashir in the room, you know, sharing their views, and to see some of the same people who had been oppressed who are now part of the civilian-led transitional government. And so it takes time, but there are circumstances in which peace does seem to prevail. And so that's one that comes to mind.
And Alex, you just shared a very, positive experience and a case you won. Anything else you would like to add?
I'll be brief. I always kind of funny stories. I'm actually ethnically Serbian too, so my name is spelled like Alexander with a K and an S, very much longer. And one of my partners in our office in North Carolina represented this artist, and they won this case down there, and she painted this like picture of him, like a self-portrait, and he was always bragging about this picture. And so I represented this one guy one time who was from Venezuela. He was detained during his proceedings, and during his proceedings, his wife was pregnant, and his wife was Puerto Rican ethnically. And we won the case. You figure, usually when you win your case, you don't see your clients for several years. And like a couple months later, they come rolling in with this like baby in a stroller. And I'm like, they're like, oh, look at the baby. And we're like, all happy to see this little baby. And they named their kid after me, right? And I remember looking at them, I was like, you're like Venezuelan and Puerto Rican.
With the KS?
With the KS, exact same spelling and everything. And so I remember like calling the partner in our office. I was like, you got a painting? I got a baby. I got a baby named after me. So
That's a great story. Do we have a question?
Yeah, I did have a question. I was just curious how PILPG's work sort of in like negotiating ceasefires in the Constitution, how you guys can use that to sort of, I guess, springboard, for lack of a better term, into building institutions in a post-conflict society and sort of ensuring transitional justice.
Paul?
No, I'm glad you asked that question, because the clients, and in particular, the mediators, are all about getting to yes now, and getting to yes now with the guys with guns. Let's just, here, sign this. This is the menu from this morning. We made a few scribbles. Let's just sign it, agree, announce a ceasefire, and we're good. And then once you've got that announced, there will be a cessation of hostilities and things will move forward. People actually read these documents after they sign them, and especially the non-state armed actors and the government actors. Drew was mentioning the Sri Lanka. the ceasefire in Sri Lanka was poorly negotiated, at least from the perspective of the LTTE. It provided that the government was able to protect the sovereignty and territorial integrity of Sri Lanka. Seems perfectly reasonable and normal. Well, when the Tamils had their arms shipments interdicted, they said, look, it says you can't, resupply your weapons. That's illegal. All the while, the Sri Lankans were retooling, building an air force in order to protect their sovereignty and territorial integrity. Words matter. There was an imbalance in the way that the words were drafted. If you're looking to have a genuine, and we've talked a lot about Bosnia, Bosnia, the Dayton Accords were a getting to yes agreement 25 years later, and there's still political dysfunction because of the compromises that were made for this temporary constitution that would only last 2 or 3 years, but would allow NATO troops to come in and replace the UN peacekeepers. Let's get to yes, let's get to now. Just sign the document. It doesn't really matter. But you've instilled political dysfunction. Darin, as he mentioned, was deeply involved in the 200-page peace agreement for Juba for Sudan. A lot of thought went into those institutional structures. And the parties realized after decades of conflict, they wanted to get it right. And you've actually had a surprisingly functional, for any post-conflict society at the moment, in Sudan with the Sovereign Council and the transformations that they're making. So the words matter, lawyers matter, get it in writing while you've got the attention of the international community.
We have time for one last question. Go ahead.
For those students who are very inspired and interested by all the, I don't know how this is working.
We can hear you.
Testing, okay. So for those students and others in the room that are very interested and inspired by much of the work you all have talked about, and I understand PILPG has some limitations in terms of internships or fellowships being remote and things like that, but whether through PILPG or other avenues, how would you recommend, we might move more into this area of post-conflict peace solution, peace negotiation, all of that? Thanks.
Paul?
So I anticipated this question a little bit. You're already in that environment and that area. And the task, you have a twofold task. Let me back up. I was raised by an engineer. You applied for things. And the notion of sort of building a network, building a career, building a profession was not how engineers did it. And Milena and I were talking earlier today about engineers. You get your degree, you apply for jobs, and you become an engineer. Doing peace negotiations, doing transitional justice, doing lawyering peace, because you're already here at Case Western with the phenomenal programs, the phenomenal professors, the phenomenal internships, you're already in the mix. It's thinking strategically about how you can continue to expand your network, your relationships, your experience, coupled with deepening your skill set. You don't actually apply to these things. You show up with a skill set, the writing, the clear ability to convey your thoughts. One of the notes I had that I'll use this question to give an answer to is, one of our clients is a cardiologist. Another one's an industrial engineer. Another one's a dentist. Another one was an investment banker. These are all foreign ministers or heads of negotiations. I don't think I've ever had a client that was an international lawyer. Maybe I had an immigration lawyer, of all things, that was a client once. And he had gotten put as the lawyer on the peace delegation because he was a lawyer. He's like, Paul, I'm an immigration lawyer. I know the client, but I don't know the issues. And so having the skill, and then doing some time at the State Department in the legal office, or even as a foreign service officer, doing some fellowships with the United Nations for the Europeans in the room, the European Union, and staying in the community. Even if you go to big law, we have 12 of the top 15 firms do pro bono work for PILPG. We have huge numbers of hours that the firms, young professionals do, and oftentimes they'll use this to continue to develop their skills and their expertise and their street cred in this field, and then they'll pop from the firm onto an envoys team or into the UN or into the State Department or something along those lines. So it's a little less precise advice than you might have been seeking, but but there isn't a pathway. I started out to be a water lawyer. My first law review article is on the protection of in-stream values in California, buying water and leaving it in the river so that the fish and wildlife can prosper. And I pivoted from that to State Department, and then from State Department to peace negotiations work. It's having the skills, and it's being constantly in the mix of international law, human rights, peace negotiations, and then making use of those opportunities. When anyone presents an opportunity, the answer is always yes. One of my students, and this will, I'll just leave you, since we seem to be terrorizing everyone nowadays, one of my students asked a question on Tuesday about, you give us all this advice, we're students, we're like slammed 24/7. How are we supposed to fit this into our lives? And fortunately, my teaching assistant answered the question and said, you will never have as much spare time as you have now. Exactly, that was the response. And it's just the notion, you just come to learn to live with the fact that you're 24/7 engaged in what you're passionate about, and then finding ways to continue to stay engaged. And you have a lot of opportunities to blog and to intellectually engage, much more so than when we were entering the environment. You can speak your mind from an intellectual perspective on a lot of these topics now in many different forms. So take advantage of doing that.
And, I'm glad Paul mentioned water law. Paul and I spent a lot of time in Juba together at this last peace negotiation, and Paul was very excited one evening to tell me all about water law. And finally, I'm like, Paul, I do international law. Please stop. I had to tease you, Paul. Really,
I managed to work it into the conversation.
yes, you love water law. Yes. Very quickly, Drew and Darin, if you have one piece of advice for the students, if they're interested, for example, in pursuing a career in the Foreign Service, or Darin, working for the U.S. government, and then Alex, you'll get the last word in terms of advice for students if they're interested in working in the area of immigration law.
If you're interested in the State Department, it's not just the Foreign Service, but we do have a number of specialists for the Civil Service. You should check out careers.state.gov, which for the United States government, for the State Department, is a remarkably informative website about information and avenues for pursuing internships and careers within the State Department. There's also a diplomat in residence headquartered at the University of Michigan, but responsible for Michigan, Ohio, Kentucky, and Indiana. That person, Lou Finter, I used to have that job, so I know a little bit about it. That person, in effect, rides circuit and visits. When I was a diplomat in residence, I visited Case Western, I visited Cleveland State for career fairs and things like that. You have specific questions. First, check out the website, then contact the diplomat in residence. There are a lot of opportunities out there, and the person will be able to help guide you as you sort of sort through how to find a job in the State Department or USAID, or sometimes also other international organizations. The State Department supports Americans who try to find jobs in UN organizations as well. Thank you.
Thank you. Darin?
Just quickly, I'll just say something about finding jobs with the U.S. government generally. The Foreign Service, as Drew mentioned, has its own Foreign Service exam. But if you're looking to join a U.S. government agency as a civil servant, USA Jobs, look at USA Jobs regularly, look for the opportunities that are presented. This is general advice. Then there are some more specific programs like the Presidential Management Fellows Program that provides opportunities to get a first job in the U.S. government. And then uniquely for all of you who are lawyers, right, that's another process to get into the U.S. government. And what I normally tell folks is, even if you apply for a job through USA Jobs, going back to what Paul said, the networking is key, right? Making sure that you know someone in the office that you've applied to so that they can make sure that your application is seen is key. And I'll leave it there, but I'll just simply say I'm always happy to speak to students. So if anyone would like to follow up after this with any questions, I'm happy to speak with you further.
Alex, you have the last word.
Thank you. So in terms of immigration, like you were saying, networking. Immigration law is a very small kind of community, so networking with immigration attorneys. There's also opportunities with pro bono, nonprofit refugee resettlement agencies in Cleveland and Northeast Ohio. Students who are here, there's a fantastic immigration clinic at Case Western, a fantastic professor if you want to enroll in there too.
Thank you. Well, that's a wrap. Please join me in a round of applause for our panelists. Thank you so much for coming.
So we've neared the end, or we're at the end. So first of all, I want to thank you all, particularly those of you who have stuck it out the entire time. It's really been a terrific day. First off, just a few words of thanks to all of you for being here. To our many guests who came from a variety of spots, thank you for braving the elements, as it were. But I want to give a special thanks to a few people, in particular the law students for the Journal of International Law, and in particular Ali Noorani Dargiri, who many of the speakers have gotten to know. He's been hounding you and seeking out your work, and really has done a great job of steering this event. Thank you to Gabe Kaufman, who's been in the front, making sure you're all talking in proper, succinct fashion, and also to Caroline Cirillo, our editor-in-chief of the journal. A big thanks to our dean, to Michael Scharf, for really leading and stewarding this event. A thank you to all the staff who really helped put this together, and in particular, Eric Seiler, who's out there. I don't know if we can make sure he can hear us, but Eric really did a phenomenal job of just taking care of everything administratively and making this happen. Just really, I promise, a very, very few quick words. Trying to sum up, and I don't know that I can do justice to this. And thank you to this last panel, because when I was out before, a few people were feeling a little glum about things. So notwithstanding much of the difficult and sobering work that you do, also I think really inspiring as well. So the ICJ statute, Article 38, certainly my students I know this, provides that the court will apply the, quote, teachings of the most highly qualified publicists of the various nations as subsidiary means for the determination of rules of law. And as of 2017, I think there's over 1,200 writers who have been cited. And in looking at these teachings, many of them are from members of the Academy, these writings, the court is looking for evidence of the law. And while being cited by the court is no doubt a highlight for any academic, we in the Academy, and I think as was evidenced here today, do not look solely to document the evidence of the law. Today's conference evidenced what is best and most inspiring about the Academy. Far from being just academic in the sense of theoretical or hypothetical, we've learned today of how the Academy can truly be a catalyst for change and innovation. We've heard from professors who are working in the field in myriad ways. It brings to mind Immanuel Kant's observation, practice without theory is blind, and theory without practice is empty. While we all write articles and books and blogs, it's never, for pretty much all of us, here just a matter of theory. The work the members of the Academy also engage in, as we have heard, do not merely aspire to citation by the International Court of Justice, though it, of course, wouldn't be too shabby a thing to happen. A number of people brought up, very powerfully the personage of Raphael Lemkin, who worked tirelessly in the 1930s for a vision of accountability for genocide being made into a crime. And he tragically, as people noted, lost some 50 relatives to the Holocaust. But he found refuge and a home in American law schools for several years, where ultimately the Convention on the Prevention and Punishment of the Crime of Genocide was realized. May the Academy always have such a legacy. As we heard today, professors are not engaged in a mere academic exercise, but are taking part in direct representation, overseeing documentation and reports of the Rohingya, leading and taking part in International Law Commission reports, directing peace talks, pushing forward new conventions, leading NGOs, critiquing the law, proposing amendments to war crime statutes, leading civic education efforts on international humanitarian law and international human rights law, fighting for asylum, prodding and pushing at the formation of Opinio Juris, documenting state practice, advocating reforms of the UN Security Council, engaging in government and military legal advisory and representative roles. The work described today reflects the dynamic nature of international law in all of its transnational components, one that demonstrates that while, as some people noted, we do operate in a positivist, consent-based system of international law that might still favor state interests, there is a role for the lawyers and the academy. That is, we, spurred by all that is best about the academy, rigorous, analytical, and thoughtful study, are unwilling to simply restate what the law is, but instead think forward what the law ought to be. Mark Ellis offered us a sobering reminder that many of the legal successes in human rights and humanitarian law that we have seen over the last 75 years are not fixed, that there are nationalist and populist interests afoot that may result in slippage and even an upward movement to authoritarian international law. Mark called for a civic education initiative that may result in greater understanding and securing of human rights, justice, and peace. I'm heartened by all the members of the academic community here, students, professors, lawyers, activists, that we can be a part of this education and be, as our conference title indicates, a catalyst for change and innovation. Thank you all. Have a wonderful weekend.